So let's again talk a little more about this problem of very long, tedious, and unproductive trial. And what we have been talking is like if we have to think of a speedy trial, fairness and human rights, like we have to think of having continuous sessions of trial. We have to think of pre-trial session, and also like we have to think of some diversions, like diverting from one way to another and not always following the formalist approach, and also sometimes agreeing to have some fast-track process. Let's have, I mean, how far this approach is important or not. We need to realize. Sure, we should not be suffering from a kind of dilemma of pride and prejudice about the system. The system is made for human beings. Human beings are not made for system. So system can change. System can be changed to the better. Change brings up new ideas. Change ends the problem that we face in the past. What is very strongly established jurisprudence that we have been talking about is like we cannot ensure fairness by staggering long and tedious sessions of trial. We spoil witnesses, we spoil evidence. Also, we create frustration in the accused if he or she is innocent, or even if he is or she is offender, that we encourage him to commit crime because she is not afraid of this whole process. Then some very important mechanisms that we can aid in the running systems, like we can meet together, we can talk, and we can design, we can specify some problem by the way of a pre-trial session. And we can come to the mind, like the judge, prosecutor, defense lawyer, and then we can say, like, this is the way that we will go. We will finish the whole process in such and such sessions in time. These are the evidences that not likely to be debated because they apparently seen as not proper, not legal. So, as I said this in the beginning, the word like a trial is not a bullfight. So we should not be taking trial as a bullfight. Therefore, I should win. I should prevail over others. All of us in trial are working for the sake of justice. Since we are working for the sake of justice, there is no room for our pride and prejudice to take place. So question is like, if the evidence is wrong, the evidence is wrong. If the evidence is wrong means either it will convict an innocent person, or it will release, or it will acquit or offender. So do we feel pride getting an innocent convicted, or do we feel pride and accuse offender acquitted? No. If not, then why we are taking trial with a perception of bullfight? So getting rid of this notion is where is the problem. So there is no problem, I think, in the system. But operating the system, we have pride and prejudice. So there is a problem that I see. So let's, go for Sang. Could you a little bit explain us, like, how do you, what problem do you see in your system regarding continuity of the session? Fast track, like pre-trial session? Do you have these systems absolutely perfectly working or not?
No, not at all.
What problems like you see
You see, for example, in our country, there is a common notion that when somebody is incarcerated or somebody is in the remand, you tend to deter crime by the end of the day. So you would rather have somebody in the cells for a longer period for other people to learn lessons from him.
Why, I mean, why in your country, for example, prosecutor, defense lawyer, and the judges are not ready to have a pre-trial conference? What might be the reason? It's a pride and prejudice, or it's not? It's a lacking of idea, or we are insensitive to the justice? What might be the reason?
I tend to think we are not sensitive to the system. We are not.
We are not sensitive to the system.
We are not sensitive to the system. We don't want to know the victim, the witness in one or another.
So this is an attitudinal problem.
Sensitivity of the problem.
Okay,
yeah.
one good point. Okay, like Kamara, can you explain, like, what do you have the problem too?
Maybe Ms. Jire can explain more than I will, but I think it might be the same problem, same problem as Mr. Sonny is explaining. And on top of that, I can maybe add the burden of workload, which does not always allow prosecutor to be available for pre-trial session. Maybe she can explain more than what I'm doing. But mainly, that could be the reason for. So in my country, prosecutors are very, very busy.
So it's not, in your opinion, it's not typically attitudinal problem. It is also some mechanical or some environmental, like atmosphere, the work environment. They also are problem.
Personally speaking, I will not speak about misconducting of system, but I think it's a matter of timetable. How to handle with cases as quick as possible, how to be as efficient as possible is always a questioning matter for our prosecutors. That's it.
Well, let's see also the share from the Central Asia, like Honorable Judge Nomato. What do you think? Like, do you often practice pre-trial, like you invite prosecutor and defense lawyer to have a pre-trial session with you?
First of all, we don't have such institution.
Okay.
Does
law prevent to do this kind of session?
Whatever, if case comes to court, we have to start the trial. We don't have pro-trial institution.
Okay.
But at the same time, it's discussing in the Senate of our republic. Supreme Court made a decision and sent to the Senate for discussing. We need pro-trial institution.
So let's listen from Abdullah from Maldives. Okay. Like as a police officer,
yeah, we
what do you think if this pre-trial session is conducted by judge between defense lawyer and prosecutor? Will you be very angry?
No, not at all, because actually we disclose our evidences to defense lawyers. So, but formally we don't have the pre-trial procedure.
Okay. So why not it, like it's not compatible, therefore we don't have, or we just are not having big number of cases, a problem, therefore we are not thinking it? I mean, what might be the reason?
I think the reason is our criminal justice system is reforming, and it started very recently. So new systems are coming. I think Ms. Sangroula will introduce the system.
Okay, Sangroula, like we would be happy to hear from you. Actually, Abdullah, I was advised by Samra to ask you this. Okay, Samra.
Okay. As Mr. Abdullah mentioned, right now we don't have the pre-trial pre-trial systems. And I think our court judiciary is not ready for having the pre-trial conferences, I think, but police and the prosecution are working together, and together means we share from the initial stage, investigation starts, they share all the evidences with us, we discuss, but there's no pre-trial conferences. I believe that because of the judiciary is not ready for this system.
Yeah. How many of us, before we became a prosecutor or the judge, in our law schools, did we study pre-trial as an important procedure of trial? It's a question for anyone.
Yeah, you asked about the reasons, in Brazil, one good reason is that the judge, the court, must be impartial. So they will not get into the case before the trial.
This is one theory, definitely.
Yeah, and so pre-trial, it's just a way to redo things. If you're going to do and settle, and then you have to go to the trial and settle again, everything that happens during the trial, the judge will settle on that moment. Like if there is a questioning about the legality of an evidence, he will rule on that moment. He doesn't need 2-3 months before sitting down with the counsel and the prosecutor to see what they are going to play. You know, it's do the same job once again.
Yeah.
And in our system, all the evidences are disclosed.
Yeah.
All of them, including wiretapping, everything. Once you make the indictment and you're going to have a trial, it can be from now to 2 months, all the evidences will be disclosed to the defense. Usually during the investigation, defense lawyers ask for the police and the investigators to collect some special evidence they can do included if the defense lawyer asks them for. So they are together with the investigators since the beginning. We can't have a person being heard at the police if he says, "Oh, I want a lawyer." Like it has to be the Miranda. You have the right to have a lawyer. So actually, I think it's very good to let the judge do what they have to do during the trial, and not getting busy in a first instance, at first, ruling how it's going to be the trial, because the procedures in the trial, they are already ruling.
Yeah, definitely one very important reason is the chance of the judge being influenced and then coming to the same decision later on. That's a challenge, definitely there is. Some problem, our friend from Thailand, he was talking about what was that actually typical problem that you were talking about?
The typical problem is that the evidence that the illegal everything, normally we have a very strict rule of ethics and rule of conduct that prosecutor will need to follow. So it's almost impossible for us to introduce the irrelevant evidence to the court of law. But most of the evidence will come from a defense lawyer most of the time, with their attempt to delay the trial or maybe just something else, and most of the time judge will hesitate or reluctant to eliminate that kind of evidence, because we believe that they should have a right to fight the case the best that they can. However, when I studied from Japanese trial, Japanese system. Now I learned that pre-trial is related with the side-by in
Yes.
judge.
Right.
You want to protect the human rights, and you want to have the common people coming in with the judge as a judge to reach the verdict. But pre-trial is necessary in case that you have a layman judge, not a professional judge. Because in Thailand we have a professional judge, and average of the court of first instance is 1.2 years. So the difference is that another thing that Japanese have is that they monopolize the prosecution. They don't have private prosecution. So when they try to schedule all of the schedule timetable of the case, you can do that because you don't have anybody to switch in the middle from the private prosecution. So that's what I thought.
Yeah, so see, I mean, from all these opinions and the ideas that you have been floating up, I did talk one very important thing in my last lecture. What I said is like there are systems built on certain principles. For instance, if you do the comparative analysis, what Americans believe is like, okay, let the police absolute power, but require the police to bring such evidence with no chance of impropriety and no chance of illegality. And then prosecutor, what he will say is, okay, enjoy the jurisdiction, enjoy the power, but I will prosecute the case only you have absolutely admissible evidence you bring to me. So prosecutor lets the police work perfectly, but then demands high standard of propriety in evidence. Okay? And then everything needs to be disclosed. Everything needs to be disclosed. One, like here in Japan, prosecutor maintains a very clear and very watchful observation over the investigation and often passing the instruction, okay, do this, don't do that. I need this kind of evidence, okay, do this. So prosecutor prevails. So therefore, police collects evidence for prosecutor, but prosecutor himself or herself is also very much involved in the process. Therefore, there is a joint action. Together, if they two people, police and prosecutor, work together, chance of investigation fair is highly. If they fight, then the chance of losing evidence is also there. So, question is like pre-trial session. If we had a system where evidence are not disclosed, I think Nepal is a perfect example. No evidence is disclosed to the defense until 25 days. Only on 25 days when the charge sheet is brought to the court and then the evidences are disclosed to the defense. By Supreme Court's interventions now, a defense lawyer can approach the prosecutors to get the copies of charge sheet and then evidence. This is another form of system that we have been following. And as this morning, a friend from Pakistan, Baluch, very rightly pointed out that, see the trial judge is there and then the remand is somewhere else he is a different judge. So who these evidence are disclosed to is a question. And there is a tendency of judges put people in remand in the police custody, not take risks. If remand has to be revoked, let the upper judge do it, then I will not be in controversy is a kind of tendency. It's exactly what the problem in Nepal. I mean, almost everybody is put into judicial custody. Bail is often not accepted in Nepal. But there is a very good system in Nepal which we never see. Like there is we call it 17 number is a very, very popular provision of the code. So by applying that, you can go to the upper court to get the wrong evidence dispersed. I mean, to get it out. But generally the tendency is that even if you go for that correction procedure of the higher court, the tendency is that, oh, that interferes the trial process. If I speak, if I get this evidence disclosed, if I get this evidence done away with, then it might prejudice the trial down. So, where is the problem? Problem is not evidence. Problem is not in system. Problem is not in proceeding. Problem is in our mind. We think that my act will prejudice. I think that this disclosure is there, so if I conduct a pre-trial session, I might be prejudiced. The evidence might be spoiled or something like that. So it is our perceived threat in our mind, a perceived kind of notion of thinking that we are afraid of using pre-trial session. But then there are two forms of pre-trial sessions that we have to be very careful. One, a bigger form of pre-trial session before the trial starts, and then so many small pre-trial sessions when the trial process is going on, like some critical issues arises, like the issue of the privacy arises, and then we do our pre-trial sessions before we go to the trial process, and then all these kind of things are there. But we cannot come to the conclusion right now here whether this is good or bad. But what I believe is that pre-trial session properly used without fear and with all convictions to impart justice, pre-trial session is one of the very important and very reliable instrument of fairness in trial. That is what is an established theory. But how do we use it? How far we are out of our perceived fairness that I might be criticized, I might be considered by others that I am prejudiced. So that depends upon our convictions, like what I am doing. I am doing justice. I am fair. If I believe that I am fair, okay. But if I am afraid of the process, then I might be contaminated. I might be considered contaminated, prejudiced. Then I think I will develop a tendency of evading the process. And generally I say that, okay, no pre-trial session. And then we therefore create more problems. We actually then gradually transform the trial as a bullfight. So what is very important, why pre-trial is so important is not to make the trial a contest or the bullfight. If we sit together and then consider the disclosures, we consider the motions, we discuss to make the thing happen within a certain period of time, and then we are ready to protect the rights of procedural safeguards of the detainee, and we are also committed to protect the rights of victims. Prosecutor is protecting the right of victim. Defense law is protecting the interest of accused. But if we concentrate ourselves to the course of justice, and when we think that when defending the accused does not mean the destruction of victim, or protecting the victim does not mean the destruction of accused. If we work that way, I think system works, and this is where I think pre-trial session works. Otherwise, do not. Sure. At this point, I don't have much opinion to talk about with this regard, but this is the right time for us to think about it. And if we think that our system should work, we have to think about it. Yes?
But I fear in systems where pre-trial session is not very well comprehended, people should fear that the prosecutor, counsel, and judge can come to some agreement about how to implement the trial. That is, trial can become a sort of performing theater instead of being trial, because there have been a kind of tripartite agreement between the different actors like judge, prosecutor, and defense.
So one very important consideration then what we have to keep in the mind is like pre-trial session is not a session to consider on the merit of evidence. It's not convened to evaluate or judge the standard of evidence. Pre-trial session's objective is only related with the proceeding. Okay, it's a procedural matter. So we should not tend to talk about the legality or the merit of the evidence. Then there is a fight. Question is like, for example, if there is an autopsy report disclosed, a pre-trial session can be had like, how can we produce this evidence? Like you can sit together in the bench, in the judge chamber, and then like you can decide, do you know everything in the post-mortem report? Is there any problem? And the defense lawyer says, no problem, I am clear about it. And the prosecutor says that I am clear too. Then it's fine. But then, if the prosecutor says it's like, what is this scientific terminology? I don't understand. Then if the prosecutor asks for the doctor to be brought for the testimony, then there is a debate now between the defense lawyer and prosecutor. Prosecutor says that, okay, how do we know about this term without expert's opinion coming and telling us? And then judge might say that, okay, this is just a terminology. Cannot we settle it by the dictionary, like the authorized dictionary? So should we call the doctor just for the sake of explaining this terminology? Then both prosecutor and lawyer at this point agree, okay, if we have an authorized dictionary to tell, then fine, okay, both of us will go by that. By that, what you can do is like, you can save almost 2 weeks time. So pre-trial session is not a trick of football. Okay? It's not I put a ball and then somebody pretends to kick, but then other comes and puts into the no. That's not a trick. What is the objective of pre-trial session is to reduce the time of trial. That means ensure speedy trial. So if that evidence vitality is there, then we should follow the time. We simply cannot make something speedy just for the sake of speedy. Speedy trial is essence of justice. Therefore, we cannot ignore speedy is what is the spirit of the notion that we are supposed to do. Therefore, we should be clear that the pre-trial conference is not for determining the merit or the standard of the evidence at that point. It is just a matter of proceeding. So therefore, I think there is no chance of judge being unfair, prosecutors being unfair, and I think Professor Morinaga, can you explain a little bit more to help me? I mean, this is very important.
Okay. Well, it's my personal opinion, my personal perspective that many of you who are kind of reluctant or feel some doubt against the pretrial proceeding or pretrial conference, what it's called, may have a notion in mind that everything has to be in open court. So the motion has to be filed in open court. The causes of them has to be shown in open court. Otherwise, it will give a very quaint notion of everything is already decided in camera, and there has been an agreement between the three parties. Some, in many cases, the defendant not being there, only the lawyers are talking, and something has been agreed upon which we cannot see from the outside, and there is a prefixed trial going on. Isn't that causes the reluctance? Yeah, orchestrated already.
Definitely.
Right?
Yeah.
But here the point is that, as Dr. Sangroula very correctly said, it is a procedural matter which is anyway decided upon by the lawyers. And the fact matter still remains open in the court. So, of course, also in Japan, there has been a big debate going on when actually making this criminal pretrial conference mandatory. Whether they should allow the pretrial conference, the judges in the pretrial conference rule on the matter of admissibility of evidence. And there may have been some dissenting opinions that no, the ruling on the admissibility of evidence must be done in open court. But now the law now says no, it can be done during the pretrial conference. And this is, again, I believe, a matter of how much trust the entire system has. How much you trust the judges, prosecutors, and the professional defense lawyers. And without the general trust of these three people from the public, I think the pretrial conference system in Japan wouldn't have been in place. So it's a matter of balancing, actually, by securing the speedy trial, by extracting, by setting aside all these frivolous, unnecessary disputes from the trial. This is something which is actually serving the speedy trial, and ultimately it will serve the rights of the defendant. But on the other hand, there is the requirement for open trial that you should not do the important, juicy parts behind doors. And I think this is a balance, and that can actually differ from country to country, depending on the public perception to that, and depending actually on the capability of these three participants there, because being impartial, even going through the pre-trial conference, can sometimes require very, very high professional ability, not being tainted by frivolous, discussions which can happen in the pre-trial conference. So the judge has to be trained to that, prosecutors have to be trained for that, and defense lawyers also, they have to realize that no, prolonging the procedure is not good for your defendant. It's you're imposing a disadvantage to your defendant. And that kind of motion, when they stick together, then there can be a good, very fair pre-trial conference. And I believe Japan did not suddenly introduce that into our system. It has been there for quite a long time, even if it was informal. I still remember my young days that there were pre-trial conferences, even if not stipulated clearly in the law. But still, sometimes if the judge feels, or if any party feels that trial can be a very nasty long one, and we should concentrate on the important issues of conflict, then we would all agree to go to the judge's chambers before the trial, and let's sort out a little bit. And let's focus on very important issues, and let other these frivolous, these unnecessary things out of the court. And that's how it started. So there was a basis, actually, before systematizing. Thank you.
The best debate with regard to these issues occurred when Bill Clinton was charged for the impeachment for this Levinsky scandal. So United States Senate, which actually was hearing the charge of Bill Clinton against for impeachment, had a pre-trial session, okay? And that you can very much see. There's a lot of detailed discussion on that. The issue was like whether to bring the Levinsky to the Senate and then with testify or not. So there was a lot of issues, like one, there was a precedent, other there was a privacy of a woman, and then there was not a public scene to be created. One very important is like public hearing and open court does not mean public scene to be created. Okay, so trial is not something like we can make it fun of others. So question is like whether fair trial or trial by media is a big debate now. So this is very important. So question is like here to pre-trial session largely is psychological. That's what I understand. Because we are afraid to take little risks. And like Professor Marinaga rightly pointed out, we are not used to do pre-trial session because we don't have a very technical skills to conduct. That's also a problem. And other is like procedure is very important. We're not talking about merit. So let's start thinking. Like Japan introduced, we may have to. It's not necessary that we go tomorrow and then start advocating. Like we can start thinking the possibility of pre-trial session being used as an effective means to ensure speedy trial. That's what I think we need to develop in the mind right now. So let's go into some other means, like what can we do? That's a very controversial sort of thing that I am going to talk to you is like, I am a great fan of introducing alternative dispute resolution in criminal justice. And I see it is possible. Theoretically, it is possible because the theory of lex talionis, the retributive concept of punishment is now gone. We are not punishing because something has been, something revenge has to be taken against. Since this concept of punishment has gone, criminal justice system is not a system to damn someone or condemn someone. Rather, understand that crime, behind the crime there are some factors, some socioeconomic factors, some psychological factors, some diseases, so they can be cured. So crime is not produced by the mind, crime is produced in the mind by the social factors. Is a new sociological theory of crime is there. Therefore, we are not going for that damnation pattern of the punishment that Europe used it in the past, Asia used in the past, and like eye for the eye, hand for the hand, something like that, death penalty, all this kind of thing. So I think we don't believe it now. At least civilized human beings have stopped believing that death penalty will bring something good thing. If we go that way, then court always adjudicates and decides cases before the parties. Lot of time the court agrees for the parties to go out of the court and settle the issue. Private prosecution to some extent is allowed by our society. In many indigenous societies, tribal societies, they have a system of repentance, and then in some minor crimes like society not orchestrating a big event, rather making it an adjustment between, many things are there. So this is a very controversial issue, therefore I don't want to go much discussion with it. What I would like to have is like, please read that article, I have written a lot. Only thing what I am saying is like, through plea bargaining, it is possible to introduce informal justice system in criminal justice system. Okay? If prosecutor represents the victim, victim can be called in the prosecution office, and victim through the prosecutions can negotiate with the suspect regarding penalties, okay, regarding the intensity of the punishment and many other things. And if victim becomes convinced that adequate compensation or rehabilitation to him or her might provide better security for her, because this gentleman being imprisoned and becoming more enemy to the victim, after coming back will create a problem to me. If this problem is resolved, which is a serious problem in the United States, like a lot of criminologists have just discussed now, then probably victim might be able to negotiate with the accused through prosecutor. Prosecutor should be a very important platform for negotiating with the victim. Then what is wrong? Like I don't say right now, okay, let punishment be wet, but this is a right time. This is a right time to think. If development would address the crime, then why there are 1 million criminals in the United States? Sure, economic development has been proven that not an answer to the crime. Less crime in the less developed society. More society is less developed, the crime is less. Because the reason is, in less developed society, communities have been intervening a lot of crimes. So they take proceeding in the community and they don't let these many crimes go to the formal structure. That's good or bad, I don't know. This is what I am suggesting is like, it's the right time to think about. If we think that better formal system is the solution, then why many crime why that much big crime in Canada and United States? Why that much big crime in Germany? Do you have an answer to that? If not, economic development is not an answer to the crime. So, what we are bound to say now that American, British, and Western developed societies' legal system, criminal justice system, are producing more criminals than, producing more offenders, producing more recidivists than addressing the problem of crime. Then, why not? Why not some informal? I am not suggesting this is the path we have to go. But what my suggestion is like, if you want to make our criminal justice system work speedily, perfectly, in some way, then we have to have some thinking of letting some form of informal practice come into being in criminal justice system. Therefore, we change in a conventional approach. There is a crime, nab the guy, bring to the prosecutor, get his confession recorded, scene of crime, and then bring to the court, then put into jail. This again, let the river flow system. Okay? This is, we need to reconsider now. If we are producing too many offenders and putting them, instead of bringing more schools, we are putting budget for more prisons. Like my government this year has less budget to the construction of university, more budget for the jail. This is the situation. Then, how can we address? Therefore, one idea, what I can talk right now is like, it is a nice time for us to think about changing the conventional approach. One, impunity and breakdown of society. How do we think criminal justice system is that every crime is against society? If somebody gives me a big slap on my cheek, then why cannot I negotiate with the offender and then get compensated? Why society has to take that slapping by him in my face is a crime against society? So this is also we need to think about it. Every crime is not crime against society. If that violates the basic norms and the basic values of the society, then it's a crime against the society. But like there is a tendency of defining that crime itself is against the society, and that's how we want to nab everyone and put into the jail. So why don't we give some like a private prosecution system therefore take place? That might be also an informal system in that. So building competencies to address the problem of impunity, the increasing threat of crimes to the security of social structure, the wider lacking of the accessibility of poor to the mechanism of criminal procedure, and reduction of harms of the crimes are agenda of its reform. Today, number of people have been jailed, they raped a poor guy, poor girl. The poor girl is not compensated by anyone, not by the state, and this rapist did not have any property, so she collapsed, he is in jail. So state ruined 2 citizens in one time. One is in jail, he is, as a good citizen ruined. Another, she became a victim, not compensated, she is also ruined. So question is like, how to build a system so that the victims becomes able to readjust it in the society, and this offender for some reason commits the crime for one time is also brought back to the social mainstream. Therefore, community should, I am not saying that let's have a informal system immediate, but what my suggestion here at this point is like, let's make community involved in the criminal justice system. Let's have like somehow, like the Western system had introduced the jury system. By jury, they involve to some extent some community. Like Japan introduced lay judges concept. That is also to some extent a representation of community in the criminal justice system. My emphasis here is like, let's bring larger community into the process of criminal justice system, and they will take the responsibility. Okay, if the person is released, then let this man or the woman hand over to the community to look after. So community does not take care of the accused and offender. It is defined as a crime against society. The state puts him to the jail. Victim does not get what criminal justice system we are talking about. I often talk to my students like this criminal justice system, this conventional criminal justice system is working in a model like. One man went to the top of Mount Everest. It was 0 degree. He died because of severe cold. One man went to Saudi Arabia. He was exposed to 50 degree, and then he died because of warm. According to the economic rule, both are alive because average is 25. So, what do? We name a person and say that you are accused, you are not accused. Or say that you are innocent. He goes up. According to the commercial rule, then why that person does not survive? Because I was condemned as a criminal, and court said that I am not. Does it mean that the person who is dead is not dead? Then state does not look for another criminal. State does not look for another offender. So my declaration of innocent does not look for another criminal. This is the system, this conventional approach. So we should not be obsessively debating on what the theories advanced developed countries in West have done it. We the Asians and then developing countries, my emphasis would be, let's start thinking some very important theories so that we can preserve our societies from being the population of prisoners like in United States. Every 4 youth has one in prison. Is committing crime. So we cannot offer this big, expensive criminal system. So the reason for reforms are several. I don't want to talk much about. Refer to chapter 3, para 1, 5, 6, and 7 paragraph. You can read. I have. You can fully read later on in the evening. No problem. So criminal justice system is monopolized by the state as a means of redressing violence of individuals against society. So criminal justice systems is monopolized by the state. My urge is that let the community be a part of criminal justice system. Crime against victim is considered as an offense against society and eventually the state. We need to reconsider this theory. The institutions of criminal justice have become expensive enterprises. My God, jail, court, prosecutors, most expensive enterprises. They are more expensive than the airwash, I think. So we are producing very expensive institutions. This is a time for us to think. So the lack of credibility in police, prosecutors, and judges, as well as difficulties to reach police stations, Okay? So, I'm not talking about lawyers. There are so many lawyers in the bottom of the sea. That's a jokes. The worst jokes in the world are found about police, prosecutor, and judge in the laws. So lack of knowledge about niceties of justice system, lack of resources to pay for lawyers, failure of state attorneys, and guarantee of the deprived people's right, and lengthy trial are few problems that we need to address. And this system is not going to address, therefore I urge you to look one beautiful film. I look a lot of film, courtroom films. It's a devil's advocate. See it and then you know what is the system of justice that America is facing today. Devil's advocate. It's such a nice portrait of the system, like how lawyers work in the society. Then criminal laws assure to protect the preserve ethical moral values. Most criminal justice system, instead of objective justice we are talking about, they pretend or they tend to protect the ethical moral values of the society. And which values are ethical moral values? My grandfather's values are good for me or not, I don't know. The formal structure of the administration of justice has never had full control over the system of dispute or conflict resolution. Never, criminal justice system has never full control over the disputes and the crimes. Many crimes are either hidden, many crimes are either resolved by the community, many crimes are either negotiated between parties themselves. If a girl is raped, and if there is a chance between the rapist and the victims negotiate themselves, they never come to the court. Okay? Only when they come to the court, then it becomes a criminal justice system. So society is already indirectly practicing a lot of these things which we don't know. Sure, what is wrong if we explore and let these things happen? And then overcrowding of the state judicial institution. My God, I don't know how Pakistan, Bangladesh, and India will be managing it. India has 30 million cases pending. 30 million, exactly like the population of Nepal. If the present number of judges have been added 3 times, I mean they already have over 1,000 judges. If this is made 3,000 or 4,000, then it takes 7 years to work every day to resolve the pending cases. Bangladesh has 1 million cases pending. I don't know how much in Pakistan. So what we are doing with this pending, like in India 2 years before release, 78,000 people waiting for the trial because they still did not have time to come. Therefore they were released sine die. I mean, the court said that you cannot keep people waiting for trial 12 years. If you don't appoint the judge, if you don't have the court, forget the crime. So ultimately, effect is like everybody was released. This is very interesting. So we have been jammed, so many crimes. So norms or principles of criminal justice system are, this is mistakes, like it is CJS, not IJS. So today we made a lot of mistake. So I'm talking about, I'm not going much about it, we already discussed. So let us think about concept of plea bargaining. That's my concept. Concept of plea bargaining, but not prosecutor and defense lawyer. Concept of plea bargaining, what I have said here is like civil cases. Concept of plea bargaining, the victim participates in bargaining prosecutor with the suspect or the suspect lawyers, and then find out some solution. If the accused agrees to pay adequate compensation to the victim, there is already a practice, and mostly in the Arab countries, like the blood money. So there is a concept of blood money. So these practices are there. If there is some kind of compromise between the victim, and always this murder is not always intentional. Like in manslaughter, negotiation would be a very good thing. And then, if these 2 parties agree, then reduce the punishment to the lesser amount, and then send the guy for a few years in the jail. Because if we put a man or woman in jail for long term, his or her children will learn crimes. So this is another criminological study right now. So question is very, very interesting. So let's develop plea bargaining. The following arguments of justification can be extended. So for these, informal justice system is a non-state dispute resolution mechanism falling outside the ambit of formal system. It works, therefore I said community can be brought in the process. Victims of crimes have very restricted role assistant to the prosecution right now. Like victim does not have a role to play. The demand for informal justice system has its roots in the penal law abolitionist movement. Okay, there is an abolitionist movement has been preparing this for a long time. The modern or trend of dispute resolution is that the conventional formal systems are supplanted by the informal system in many other commercial cases, civil cases. In family matters, informal system have become a very, very popular part. Then it is time for us to think through plea bargainings, look for some options. So fostering culture of pre-trial conference, we already did discuss a lot. Pre-trial conference is especially useful for understanding of the gravity of the case and the pleas of the parties. So what is very significant in the plea bargaining is like when people have a pre-trial conference, prosecutor knows what argument the defense is going to make, and the defense knows what argument the prosecutor is going to make. So they need not then exploring myths. They should not therefore hitting a dead horse. They know that, okay, prosecutor is going to argue this logic, therefore I can prepare only for this. Okay, defense lawyer is going to raise this argument, therefore I can prepare. So they become too confined in time. So 10, 12 minutes, 15 minutes should be enough there. So that makes the pre-trial conference make the trial process more transparent. Threats and perceived threats will make it mystic. It makes it very mythical. But the objective of the pre-trial conference is to let the parties to understand their stand. And if they discuss in front of the judge will not speak much. Who speaks is like, this is the parties, okay, this is my stand. This is the strength of the evidence that I'm going to find. So the people will be quite understanding each other. And what is very important is like, we cannot fight in dark. Criminal justice system cannot be fought in dark. It's transparent process, therefore disclosure is there. Why then we are afraid? So this is one, we need to develop pre-trial conference is the justification, which Asian trial system do not have much. Therefore, by this, uncertainty of the trial is serious problem in lack of understanding of the proceeding or motion required by the case. Everybody, prosecutor and defense lawyer are afraid of each other. And then they are preparing in a way that it's something like unusual thing is going to happen tomorrow. So everybody is susceptible, everybody is doubtful. And then when these people come to the court, they come like enemy. And then this uncertainty will be addressed by the pretrial. Possibility of manipulating witness and tampering evidence is a serious problem. Because disclosure takes place here, then there is no time, there is no process of tampering of evidence after that. Without pre-trial conference, the prospect of developing a strategy for defending claims of pleas becomes an elusive act. So, if I don't know the issue that other party is going to raise, then on what basis do I prepare? So I will be hunting, okay? I will be hunting for a hidden treasure. If I get it, I am rich. If not, then I'm gone. So, legal profession is becoming a hunt for the hidden treasure because of we are not using this pre-trial conference. So pre-trial conference is therefore is a very important thing that I understand, and I don't have fear to use it actually, because what I believe is like by it the justice can be brought in. So the pre-trial conference is also an important platform for developing diversion approach. So it is in itself as a diversion approach. If we believe in diversion, we need to believe, I think, with it. That's what I said. So please refer to chapter 3.2. I have discussed about it. There are examples. You can read more. Now, almost coming to the fostering culture of fast-track trial process. Refer to chapter 3.3. I think Nepal has made a good beginning about it. there are two judges here, and one of them is a very, Mr. Wagley is a very proactive judge, known, young proactive judge about the fast track. But prosecutor and defense lawyer are creating such a huge problem for them to use the fast track. Even judge is interested, they are not. The question, and again, like we are talking again the same thing. Like the trial is taken not as a matter of justice, but it's a bullfighting. It's a raising bulls come to the Madrid stadium to fight. It's something like that we have been taking the trial. So, but fast track in two ways. One, to take summary trial process that Japan has introduced, and I think it is very nicely working. Another dimension of fast track is like often in some important cases, like the court can move to the spot and then can do some trial activities in itself in the spot, like and then see the situation. Therefore, sometimes judge, prosecutor, the defense lawyer can come to that particular spot and then can do some summary trial sort of thing, which actually make the situation itself makes everything clear. So this is what the notion. And again, this fast track motion somehow implicitly calls for informal justice process to be adopted again. So there is something. So offense such as rape, trafficking of human beings and drugs, counterfeiting of currency, violation of immigration rules, and so cannot be waited for long to be tried and tedious process. For example, suppose that I am caught in Tokyo for immigration rule. Why should I be for 1 year? Why should not there be a fast track for 3 days? And if I made a mistake, okay, send me back to Nepal. Why Japan would be happy to put me in jail and give Japanese people tax, a good food to me? So this is a foolishness actually. If I commit a mistake of coming to Japan illegally, the best way is to capture me in the airport, have a trial over there in the airport, summary, and get me back. So this is what is called, fast track. So, simple things. So, if we make it simple, then it works simply. So, question is like, fast track modules addresses problem of formalism nurtured by a procedural system. Fast track is important because we are doomed by the formalism in system. So, almost last slide is therefore, you can go for informal justice system, you can go for fast track, you can go for pre-conference trial, and also continuous hearing. If these four things are properly used, then we can create trial system as a perfect bottleneck with proper lead, not infected lead, or also not loose lead, where the core can be preserved well inside. Okay? Therefore, our systems can work. So, fair trial is a substance as well as process of justice. Fair trial is not, or the fairness is not only process, it's also a substance. You cannot buy a good thing with a bad money. Counterfeit money cannot buy a good computer, does it? So if you want to have a good computer, you have to produce a good money. So therefore, fair trial is a substance and process form. Most Asian developing countries have nurtured a culture of dogmatism. We are so dogmatist. We are so dogmatist, like we want to do what my fathers have done. I do not want to change. Staggering trial sessions, therefore, are so nice thing for us. Like we are talking in front of the judge for a couple of hours, your honor, your honor, your honor, and that's good. This is what we mean justice. That's not a justice, okay? That is justistic, not justice. Participation of victims in plea bargaining session in prosecution office. So let's make our prosecution office a little bit more responsible. Let the victims work with them, and then also possibility of bargaining with the accused through prosecution. Therefore, we can get the number of the cases reduced, or we can get the population in prison reduced. Pre-trial conference and fast-track trial, not trial again. Sonam, you didn't see it. Okay, it's trial. Can also be effectively used to reduce the time and complexity of trial. So this is therefore we can make a perfect bottleneck like that. So this is what I have to say when I finish. I think we discussed a lot, but still, do we have some time to ask questions? No. If you want, please like this.
Okay. It's Fabish of Prof. Moria. First, I take just one question. Any question? No? Okay. Okay. Dr. Sangroula say here until tomorrow night, so we can discuss maybe in some
Lunchtime.
yeah, lunchtime or dinner time or some time. Okay. Thank you very much, Dr. Sangroula. This lecture is really suggestive and, as I said, it's kind of inspirational. So, it's really useful for our discussion. Thank you very much. Please applaud.
Okay, as I mentioned, we will leave UNAFEI tomorrow after 8 o'clock, so please assemble at the main entrance at 7:55. Okay. Thank you very much.